Welcome back, everyone. Let's get right into your final review block. Today, we're building your ultimate cheat sheet for Tuesday's exam by mastering the absolute foundational mechanics of Zambian jurisprudence. Think of this masterclass as your survival guide. We aren't just memorizing dry facts here, we're learning exactly how to spot the hidden issues and apply the precise authorities that will score you maximum points. If you want to understand how the Zambian legal system actually ticks, from the highest courts all the way down, you are exactly where you need to be.
Here's our game plan for today's session. First, theories and sources of law. Second, statutory interpretation. Third, procedural rules and precedent. And finally, we'll wrap up with the legal profession.
All right, let's kick things off with Section 1, Theories and Sources of Law. Look, when you're analyzing foundational legal theory, Henry Capocco versus the People is literally your golden ticket. If your examiner asks you to justify the legal order as an actual system of justice rather than just a bunch of arbitrary rules, point out how the Constitutional Court referenced Kelson's vision. Kelson saw the legal order as a system of norms derived from a basic norm. The court also invoked Hart's idea, the union of primary duty-imposing rules with secondary power-conferring rules. And they even highlighted Fuller's internal morality of law, which is the idea that a legal system absolutely needs clarity, certainty, and utility to even qualify as law. Dropping these names is a brilliant way to show you understand the deep philosophical architecture of the court's reasoning. Definitely write that down. Now, picture this. Here is a classic Socratic trap they are definitely going to set for you. What happens if your hypothetical exam scenario features a signed international treaty, but it hasn't actually been passed by the Zambian parliament? Can you use that treaty to win your case?
The answer is a hard, absolute no, and you must cite Zambian Sugar plc versus fellow Nyanzaluka to prove it. In that specific case, an employee's termination totally complied with local conditions of service, but it violated an international labor convention. Well, the Supreme Court established unequivocally that international treaties, even if they are signed and ratified, cannot be enforced in Zambian courts unless they are actively domesticated by an act of parliament. So the big takeaway? Domestic law completely overrides undomesticated international conventions every single time. Beyond the Constitution and statutes, you really need to know your secondary and customary sources. Highlight these 4 citations in your notes. Use the Minister of Information versus Kembo case to prove that dictionaries are perfectly valid secondary sources for defining terms. Cite the High Court in Mike Masanade Piri to show that books by learned authors are also authoritative. Now, for customary law, Kaniki versus Jairus is your absolute benchmark. It confirms that while customary law is valid, it completely fails if it's repugnant to natural justice. And finally, use Mumba versus Electoral Commission of Zambia to demonstrate judicial notice. That's when a court just accepts widely known facts, like a new constitutional amendment passing, without needing formal evidence.
Moving right along to Section 2, Rules of Statutory Interpretation. Think of this as your golden matrix of interpretation. It neatly organizes your exact exam answers. If you need to apply the literal rule, rely on that Chimbo case again. The Supreme Court literally used the dictionary to decide that a recommendation is just an advisory suggestion, not some binding command. But wait, what if a literal reading creates total absurdity? That is your cue to spot the mischief rule using Attorney General versus Akashambatwa. In that one, the Supreme Court rejected a literal reading of the Constitution that would have unfairly cost MPs their seats just for resigning from their party. And finally, use the Resident Doctors Association case when applying a generous purposive approach. The court looked at the true purpose of the law, which was to protect fundamental freedoms of expression and assembly against unlawful police restrictions.
Okay, Section 3, Procedural Rules and Precedent.
So imagine you get a trick question suggesting that Article 118.22e of the Constitution abolishes strict criminal procedure simply because it says justice should be administered without undue regard to procedural technicalities. How do you counter that?
Bring Henry Capocco right back out. The Constitutional Court was crystal clear here. Article 118 is a flexible principle, sure, but it is not a wrecking ball for the Criminal Procedure Code. You've got to argue that rules governing witness testimony, like Sections 207 and 208, are designed to preserve the pure integrity of the truth-finding process. They are substantive rules, deeply grounded in Kelson's basic norms. They aren't just annoying technical hurdles that a judge can casually brush aside.
Here is another procedural trap, the exact definition of a court's power. Whenever the topic of jurisdiction pops up, do not just give a vague, hand-wavy answer. Explicitly use the two-pronged definition laid out by the Supreme Court in Zambia National Holdings versus Attorney General. First, it's the authority a court has to decide matters litigated before it, and second,
It's the authority to take cognizance of matters presented in a formal way for its decision. Nailing that exact two-part definition shows the examiner you know your case law cold.
Definitely add these two cases to your procedural toolkit. First up, Casote versus the People from 1974. Not only does it provide the exact legal definition of forgery, but it's your main anchor for demonstrating stare decisis. It proves that lower courts are absolutely bound by the latest decision of the Supreme Court if there's ever a conflict. Next, look at the incredibly recent 2025 Constitutional Court case of Miles Bwalia-Sampa. If you get a question on third-party interventions, use this one to show that an amicus curiae, a friend of the court, is admitted entirely for the court's own benefit and convenience. Because of that, their application shouldn't be derailed by mere procedural technicalities.
And finally, Section 4, the legal profession. Time to test your ethical instincts. Say your client is completely broke. They have no money to pay up front. So, as their counsel, you agree to a no-win, no-fee arrangement, where you just take a 30% cut of the final judgment. Is that actually allowed in Zambia?
Absolutely not. Do not fall for it. If you see this on the exam, cite Kuta Chambers versus Simbolo immediately. The Supreme Court affirmed that contingency fee agreements are strictly illegal in Zambia. A legal practitioner simply cannot claim a percentage of the total judgment sum. The golden rule is that legal fees must be properly taxed, which means they have to be reasonable and strictly calculated based on the actual work done, not just some pre-agreed percentage of the final payout. Speaking of strict rules, you've got to write down this brilliant quote from Indico Estates Development Company versus Marshall Chambers. Counsel is not entitled to inconvenience the court with untrue stories. It perfectly establishes your duty of absolute honesty to the court. But honestly, this case is also vital for billing disputes. It explicitly ruled that the instructing client, the person who actually retained your services, is the one primarily liable to pay the bills. That holds true even if someone else is the actual beneficial client who gained from all your hard work. Now, let's talk about the limits of confidentiality. Use the Bank of Zambia case to contrast the immense power of legal professional privilege against its strict boundaries. Yes, advice given to management is privileged. We know that. But the court held that this privilege is not absolute. It vanishes entirely if a lawyer advises a client to suppress evidence of mismanagement or to inhibit disciplinary actions. It is a very fact-sensitive balancing test, and privilege absolutely cannot be used as a shield to hide misconduct from litigants. Finally, round out your ethics answers with these two powerful authorities. First, use the Mabuye case to prove that the overriding criterion for the legal profession is irredeemable integrity. In that situation, a former magistrate who was dismissed for misconduct was blocked from enrolling as a law student years later. It proves that sometimes no amount of repentance can repair a compromised integrity. Second, use Sebastian Saizizi Zulu to demonstrate the boundaries of courtroom conduct. If you recklessly accuse a trial judge of bias without highly reliable evidence, like alleging they promised to fix a defendant, that is outright contempt in the face of the court, and it will earn you a prison sentence with hard labor. No joke. So look, the crucial point we've covered today is that you now have the exact authorities that Kelson and Hart would applaud. You have the precise definitions, the procedural shields, the interpretation matrix, and the unbending ethical boundaries. You've got the cheat sheet. But remember, law isn't just some static list of rules. It's a living system of justice applied to really complex human problems. When that exam paper flips over on Tuesday and the facts inevitably twist in a way you didn't expect, which landmark ruling from today's session will be your ultimate defense?